AB9.
There's an AB9.
AB9, so I have, mostly I have the law number so you can look it up if you want to. This is Department of Fair Employment and Housing. They extended the deadline on when an employee may file a complaint against a former employer even, up to 3 years. Okay, get that? So they've left employment. They have up to 3 years to file a complaint for discrimination or harassment or retaliation of either of those. Okay? So what that means is what you really need to do is you need to be diligent in documenting performance issues. You need to make sure that you're holding on to your employee files to cover that period of time, because they have 3 years to file, then they have another year after that to bring a lawsuit. So you're really all told, you're talking at least 5 years. So it's so critical.
You should be keeping your records for 5 years if you're employed anyway.
Well, you should.
According to the IRS,
yeah,
that's the one.
but well, that's not employee files. I'm talking about employee files. So you want to make sure that you do a really thorough job with documenting any employee performance issues, including perhaps attendance or anything like that. Plus, if they're not doing a good job, you want to make sure that you have that thoroughly documented. It needs to be done also fairly. You want to show fairness in those. You have to notify your employees, and there's a lot to that in performance management. So any questions about that? Okay. I think AB5 sucked everybody's energy up. Okay, now here, this is an interesting one because I just found out yesterday, I had already had these slides in here, but I thought, you know what, we're gonna go over it anyway. AB 51 is mandatory arbitration. An employer, and I always recommended this for my clients, have a mandatory, as a term of employment, have a mandatory arbitration policy and agreement with employees, because it helps minimize legal fees if you should get kind of employment dispute. Here's the thing. As soon as Jerry Brown was out and Gavin Newsom was in, the people that wanted to put this in place, this law in place, were successful. They got Gavin Newsom to sign this bill into law. Okay, so it went into effect. It was supposed to go into effect January 1, 2020. However, there were some businesses over in some part of California, I think in the Central Valley, brought a lawsuit against the state to put a, what do you call that? So that they cannot enact it, all right? So it's not in effect yet, but today, it's today's date, they're supposed to be revisiting that and coming out with a decision. There was in front of a district judge, and she said, you know what, this doesn't make sense to me, so I'm going to be having to study this, and I need more information. And so right now, it's not in effect, so arbitration agreements are still in, you can ask, but this is my advice. I would wait. Currently, if you have any employees that have signed an arbitration agreement, they are grandfathered in, and you can still have that arbitration agreement with your employees if it was in effect before January 1st of this year. I would hold off and having anybody else sign one, like if you have a new employee since then, until they make a decision on what they're going to do moving forward. Yes?
Sorry, Karen. Well, wouldn't it kind of be like the non-compete clause? You can still leave it into your employee handbook or things, but it's not enforceable?
I don't recommend that.
Okay.
Because anytime you put anything that's unenforceable, it puts the whole thing in question. Even if you have a caveat that says anything that's unenforceable is still in effect. I don't think it's wise. I think there's too much scrutiny then that will be put on the whole document. You don't want that.
Okay.
So yeah, you're welcome. So this is what we're doing going forward, is we are putting in, we're updating handbooks right now. And I just briefed my staff that how we're going to do this is we are going to leave the arbitration policy in there, and then we're going to wait until they decide. And if the court says, yes, we're going to leave it stand, and you can no longer have mandatory arbitration agreement as a term of employment. We will put in a disclaimer in the policy that says anyone hired after January 1st, 2020, this does not apply to. Yes?
You know how sometimes employers will pay for moving expenses or bonuses, signing bonuses, or your tuition for your master's degree, and if you leave the job too early, you have to pay it back.
Oh no, that's not allowed.
Is that can they company like force you to pay back the tuition that they paid on your behalf, or the?
I would say that I don't feel like I'm qualified to answer that question. I think that an attorney would really need to be answering that one. Because as far as I know, and things change, right? It evolves, it changes, and I cannot see it being loosened up from where it was, a few years ago. But the last time I looked into that, I was told you can not recover expenses from an employee unless you have a signed contract. So if you have a signed contract that says, I went and got my master's degree, you paid for it, I agree that if I leave before 2 years, I will reimburse the company 50% or something like that. They cannot ask for the full amount, I'm pretty sure. Does that answer?
Yeah, so if you sign a contract, then you pretty much have to.
Yeah. It has to be a separate contract. Okay? Anything else on that?
This last question on the ABC.
Yeah.
So, because you specifically said that from the time the employee was hired, if your policy changed from the time that the employee was hired, and you say that today you want to do mandatory arbitration, but they were hired 5 years ago, can that be enforced retroactive? I mean, can you?
It depends. So it depends on what they do with this law.
Okay.
If they take away this law and say, you know what, we're not going to have it, we're going to say that that's unconstitutional or whatever, that we're not going to allow it, then yes, you can. So if we act like this doesn't exist,
Right.
then yes, you can. If, however, they decide that it's going to stand as is, then no, you cannot. So the mandatory arbitration, you cannot ask your employees to sign an arbitration agreement as a term of employment, or for class action waivers. So that also means in your arbitration agreement that would be included, so that they cannot participate in a class action suit against the company, or jury waivers or agreements that require an employee to take steps to preserve their rights as a term of employment. And don't ask me about that one because I've never worked with that one, but I can imagine a lot of different scenarios where an employer might ask for that, but I think that would be, I don't even know how they could ever enforce that, ever, even before this law. But here we go. Okay, so this is the exclusions. Employee arbitration agreements that were in place before January 1st remain in force, unless you decide you don't want it anymore. I've actually had clients I recommended they do an arbitration agreement. I said, well, they're still letting you ought to do it. Oh, I don't want that. Okay, I know. Also, any arbitration agreement that's in a severance letter. So if you prepare a severance letter for an employee, you can have that arbitration included in your severance letter, and include, which I always recommend, a waiver for class action. Okay, and then any arbitration agreement that is governed by the FAA, meaning the Federal Arbitration Act. Okay? All right, moving right along. This is SB 188, the Crown Act. It's creating respectful Workplace Environment Act. And what this is doing is amends the definition of race under the Fair Employment and Housing Act to include traits that are associated with race, including hair textures and protected hairstyles. And what that means is employers cannot demand that a person that has an ethnic hairstyle has to do something else with it. Cannot. That is now prohibited. It's now included in the definition of race.
That's already law here in California?
Pardon me?
That is already law here in California?
Starting January 1st.
Okay, because I know it's, on federal level, it's just a bill.
Well, I don't know about the federal, but here in California, it's already in force. It's effective January 1st. Okay? So you cannot, you know, just the same, like for example, in the past, a couple years ago, they came out with, for religious articles or garments, right? So that including headscarves and jewelry and all of that. They included that under the definition of, that was under Title VII, that was included. That was under the federal level. So they're including this, and they want to prohibit any grooming practices that disproportionately affect people of color, okay? And here's what you need to do. You look at your dress code in your employee handbook, and your dress code in your employee handbook should say, let's see what I have something in here. Nope, that's not it. It should say that as long as people can wear their hair any way they want to, as long as it's kept neat and groomed. So that doesn't mean put a comb through it. Like, I never put a comb through my hair, okay? If I had to work for somebody that had that requirement, I would not, they would have to write me up or something because I just wouldn't do it. So it's that kind of thing. And security regulations still apply. So there's other things, as long as it's for what's essential for the workplace, what they must have in order to do the job. Any questions on that?
Limit of that one, because there's been a lot of people that go to proms and they wouldn't be let in because their hair or dress was a certain way. So does it extend to kids?
This is employers.
Employers.
This is
Oh,
employers. This is all employment. All of this stuff that I'm talking about is employment. So in terms of what a school would allow, I would imagine that they would want to be in alignment with employment law.
I would hope so.
Yeah, you would think. Okay, so this AB 1223 organ and bone marrow donor leave. So this is only for those employers that have 15 or more employees. Now, when I say 15 or more employees, I don't mean full-time. I mean any status of employees. If they're part-time, temporary, seasonal, 15 or more. Currently, any employer that has 15 or more must provide paid 30-day leave, okay? This new definition has expanded that to add an additional 30 days unpaid leave. So 30 business days, this is in addition to the 30 days paid leave for organ transplant, organ donor, and then 5 days for a bone marrow donor. So that what they did was they expanded that so that if someone wants to be an organ donor, say they want to donate a kidney to their brother, they are already entitled to 30 days paid leave by the employer. They're also entitled, if they want it, 30 days unpaid leave. Okay? If they want to donate bone marrow, they have 5 days paid leave, and then they're entitled to an additional 5 days unpaid leave. And during that time, the employer must maintain the employee's health benefits if you have them. Yes?
That wouldn't apply to part-time employees, it's only full-time employees, I'm assuming.
No. No.
Really?
Yeah.
It says
But-
15 employees.
Yes.
So no, part-time employees, let's say if you're working 4 hours a month, and you have to give them 30 days paid,
Well, I think that would have to be looked at, scrutinized. So, yeah, I can't say in that particular situation, if you have a very part-time employee, that I can't see that you would be required to do that. But I'm not an attorney, and I can't say definitely for sure.
No,
Okay?
more curiosity,
Yeah. Anybody
Well, it
else?
gives them the time anyway.
When you say paid leave, they're pulling up, the employer's pulling those funds from sick pay, or is that just regular?
That's regular pay. Okay? And by the way, if you're maintaining their existing health care coverage, there's a way, you don't have to just pay it out of your pocket and they don't pay you back. You just have them, you coordinate and negotiate terms for them to repay you that. Their health care premiums, if you're maintaining their premiums.
Oh, okay.
Okay? Any other questions? Let's see. Okay, so SB 142, this is lactation accommodation. And this applies to employers that have 4 or more employees. And again, the 4 or more employees, it just doesn't matter if they're full-time or part-time. Okay? The employer, to the best of their ability, must provide a lactation room that has specific requirements. Now, the content in blue is the new law. Okay, they expanded it. And actually, this is San Francisco. San Francisco had this in place like 5 years ago. And so what they did was they just took that and they added it in. They said, that's a good idea. So the most important thing is that the lactation accommodation cannot be in a bathroom or restroom. Cannot. It has to be in a separate space that's private and that is secure, so that if the employee is in there expressing milk, that nobody else can just intrude in. So it has to be private, locked door, no, able to close a shade in the window. They need to have access to a sink. Now that doesn't mean it has to be access to the sink with running water in that room, but it has to be in a close proximity. A cooler would be fine, a little refrigerator would be fine, where they can store milk. That can't be like at the gas station down the street. That has to be someplace close by to their workspace.
Can it be the refrigerator that people also put their lunches in, or is
It can be, as long as they have a place that's kind of shielded off. It can't be though where they keep chemicals to work on, Yeah. They need to have a place to sit, and they need to have some kind of form of electricity, so some power. So it doesn't have to be an outlet. It could be an extension cord. It could be a charging station, something like that. And, okay, so for example, if you have a small premises and you don't have a lot of office spaces that are confined, they will accept an exemption, but you have to be able to go to the mat to prove that you cannot accommodate. It's not a reasonable accommodation. Yes?
So when you say a private location, does it have to be with a door and a window? Or can it be like a curtain shielding off like half of a room or a piece of the room?
I think that might be okay, but it probably is going to be up to the employee whether or not she's going to feel comfortable there, like does she feel private enough. So any other questions about that? No? Okay, moving on. All right, so this is what I recommend that you do is, first of all, if you have you need to have a policy in writing for your employees so that they know in advance. And you should have things set up before you need it. So if you have an employee that's out on pregnancy disability leave, you want to find out if you need to accommodate that employee before she returns to work, right? So you want to have all of this done. You want to have the lactation space identified. You want to make sure that you have a way to secure it, that you have all of the other running water, refrigeration, whatever else you need. And it needs to have, that space needs to be marked, meaning that you have to identify it. So say you have a room, and I've seen employers use a conference room for that. They need to have a sign on there or a way to identify that when the employee is going to be using that it says on the door, do not, enter, it's being used, so that people understand that, or if you can't lock the door. So my idea is best to have a locking device on your door so that people can't just walk in. and then grant a reasonable amount of time for expressing milk. So the law says that employees can have up to 20 minutes that's paid. Okay, so that would be, and you want to have all those details in your policy in writing. How much time you're allowing, and if they need more time, you can have them clock out if they're a hourly employee, and you don't have to accommodate, like hours. You don't have to do that. That's not the intent of the law. Any questions on that?
I've seen them at the airport, little, like, they look like trailers
Yeah,
for the lactation.
yes.
Is there an employee minimum, or, yeah, do you have to have a number of employees before you have to comply?
Four employees. Okay, here's some, and as I said, make sure that your policy is in writing and it's up to date. And you also need a procedure, and this is also in the law. You must have a procedure on how your employees are going to know how to request accommodation. So what I prefer and what I always suggest to my clients is anytime you have, like when you have paid sick leave, vacation, anything that or leaves, or anything else that needs accommodation, a form that says, or so that they know specifically what they are to do. Fill it out, put your name, what you need, and submit it to your supervisor, manager, the owner, the executive director, whoever it might be, for approval. Okay? And by the way, procedures should not go in your employee handbook. Should not. They should be separate.